you very much, Mr. Weir. It's a pleasure to serve under your chairmanship, and I bear your exhortation about brevity very much in mind. And I congratulate the Honourable Lady, the Member for Makerfield, for following your strictures, and I will do likewise. I speak today as, first of all, and I should make a declaration, as a former practitioner in legal aid at the bar for nearly 20 years, and somebody who has had wide knowledge of both criminal, family and civil legal aid in those years. And it's been a very changing picture over the 20-year period of my practice. I hesitate before using the phrase permanent revolution, but it has felt like that at times, particularly in the context of the last 10 or so years, when, with consultation after consultation, the previous government bombarded the profession and literally made it revolve on the spot with a number of questions it kept on asking of the system. The reality is this, Mr. Weir, that whoever had been elected to government last year would be dealing with the legal aid issue. And whoever was sitting in the minister's seat would no doubt be putting forward proposals that would involve a reduction in expenditure of legal aid. And I think it's important that we take out any party politics from this issue, because I really do not believe for an instant that that either helps the debate or in fact puts it in a proper context. I'm a member of the Justice Select Committee, and as has been referred to by the Honourable Gentleman, the member for Cambridge, whom I congratulate for securing this debate today, the committee produced a report in recent months based upon a series of evidence sessions about the Green Paper. And it is a report that I commend to you. It is a report that was the result of a lot of hard work from committee members. And it came up with a series of conclusions and recommendations that I know the Minister is considering very carefully indeed. And I should say at this stage that the Minister has at all times been extremely open to suggestions and proposals and counter-proposals about the future of legal aid. And the work that he is doing in this area is something that I pay tribute to. However, the report that the Justice Select Committee produced makes for, I would submit, some challenging reading. And one of the most important and fundamental points that it seeks to make, Mr. Weir, is the dearth of evidence that exists at case level to work out what the key cost drivers of legal aid expenditure in England and Wales are. In other words, there is precious little evidence to help decision makers come to a view as to why it is that we spend more on legal aid per head as a percentage of GDP than other comparable countries. And it is the strong view of the committee that far more academic research needs to be done domestically in order to work out the reasons for expenditure on legal aid. As part of my research into the subject, a couple of facts shone out. One was the fact that we tend to prosecute many, many more cases in England and Wales than in other jurisdictions. And also the fact that some of our processes of law are much more complex than in other countries. One example I can think of is in the field of welfare benefits law, which without the guidance and help of a lawyer can be a real minefield for litigants and lay people. But an important fact that we must not overlook is the global view of expenditure on legal processes. Because I think it is wrong just to look at legal aid in isolation. We should be looking as well, Mr. Weir, at the cost of prosecutions and the cost of court processes, that is the judiciary. And when you look at those three areas together, the Council of Europe's most recent report offering comparators between England and Wales and other European countries shows that our expenditure as a percentage of GDP per head is equal to the average. So suddenly, the assertion that we spend more on legal aid compared to other countries becomes a little hollow, I would say. And therefore, perhaps we should be very careful before basing any policy developments upon assertions such as that. Having said that, it is quite clear that there are a number of areas where we can make reforms to reduce expenditure on legal aid. Now, we were particularly struck as a committee by the evidence of Sir Anthony May, the President of the Queen's Bench Division, who reminded us that when it comes to the scope of judicial review, there was a case to say that for what has been described by a Lord Justice of Appeal as the merry-go-round of appeal on appeal relating to asylum cases, there was a case to be made for the removal of legal aid in those cases. Now, there could be a substantial saving to be made there, and as my honourable friend, the member for Cambridge, said, it is incumbent, I think, upon either committee members or members of Parliament to come up with constructive proposals which can offer real and effective savings in expenditure. But, you know, the problem doesn't begin and end with the law. As has already been said, the quality or lack of quality of decision-making in government departments has led to an explosion in appeals. The Department of Work and Pensions is a notable example. A statistic that came before our committee was that 92% of decisions that were appealed from the DWP were successfully appealed. Now that speaks volumes, I'm afraid, for the poor quality of decision-making. And it was the view of our committee that we should adopt the polluter pays principle when it comes to the award of costs against departments that make poor decisions resulting in successful appeals. In other words, placing an incentive upon government departments to get their decisions right in the first place. Now, I know the counter-argument has been that that merely involves a transfer of money from one department to the other, but we really need to get incentives right so that we can avoid the need to go to law in the first place. And I think that sort of approach across the piece when it comes to poor decision-making is one that we should be encouraging. There were many other points raised within the report, some of which have been covered already, and I don't seek to repeat them now. But, and I know the Minister will forgive me, he's heard me say this many times before, and I make perhaps no apology for repeating it again. The dangers in adopting the narrow definition of domestic violence and the narrow definition of reliance upon previous court orders, as opposed to undertakings or promises made by people to the court, open up a whole host of problems when it comes to making sure that people have fair representation in often quite serious cases. It simply is not a good definition to rely upon, and in our report we submit that the definition should not be relied upon, or at the very least it should be expanded to include domestic abuse. And I would go further and say a course of conduct representing domestic abuse to avoid the quite proper concerns I think the government has about one-off situations being characterised as perhaps something more serious. So for all those reasons I would submit that, and I would argue that more work needs to be done to improve the scope of the Green, to improve the ambit of the Green Paper, and to make sure that any changes to the legal aid system do not disadvantage those who genuinely need it. Thank you.